Now that you have completed your forms, you are ready to copy and assemble them for filing. If you have filled out the Sacramento County Superior Court's Guardianship Part 1 packet by hand, you should remove the staple, locate the first page of Form GC-210P, Petition for Appointment of Guardian of the Person, and then set aside all pages that were before that page. Keep the remaining pages in the order that they were in the packet. If you have filled out the PDF file on your computer, you will wish to print out all the pages starting from the first page of Form GC-210P, Petition for Appointment of Guardian of the Person, to the end of the packet. Keep the forms in the order that they are printed out. The first 4 pages are Form GC-210P, Petition for Appointment of Guardian of the Person. Move these 4 pages into a separate pile. Below that should be Form GC-210CA, Child Information Attachment. This form is 5 pages long and is attached to the Petition for Appointment of Guardian of the Person. Place these 5 pages below the petition so that the combined packet is 9 pages plus any attachments you might have inserted. If you are seeking guardianship of more than one child, a separate 5-page attachment is completed for each child and would be placed below the previous attachment. Once all GC-210CA child information attachments are combined with the GC-210P Petition for Appointment of Guardian of the Person form, paperclip that group together as a single petition packet and set it to the side as the first form to copy in your 2-copy pile. The next 5 pages are the Duties of Guardian Form GC-248. Separate these 5 pages, paperclip them, and place them next in your copy pile. After that is the Confidential Guardian Screening Form, Form GC-212, plus the local form, Confidential Guardian Screening Form Additional Page, Form PR/E-LP-008. Take the 2 pages of the Confidential Guardian Screening Form and behind it place any attachments you have prepared for that form, and finally end with the Confidential Guardian Screening Form Additional Page. Paperclip these pages together and place them into your copy pile. If more than one person is applying to be guardian, repeat this step for each person's Confidential Guardian Screening Form, attachments, and additional page. Next is the declaration under the Uniform Child Custody Jurisdiction and Enforcement Act, Form FL-105/GC-120. Take the 2 pages of this form, plus any attachments that you may have used to list additional children or addresses, and then 1 Indian Child Inquiry Attachment Form ICWA-010A per child. Paperclip these together and place them next in your copy pile. The 3-page Order Appointing Guardian or Extending Guardianship of the Person Form GC-240 is next. Paperclip these 3 pages together and place them into the copy pile. You will have 1 copy of this form for each combination of guardian and child, so for example, if a single guardian is seeking guardianship of a single child, there would be 1 order. 1 guardian with 2 children would result in 2 orders, while 2 guardians with 2 children would require 4 orders. Finally, the Letters of Guardianship, Form GC-250, consists of just 2 pages, but you would have a number of these equal to the number of orders that you created in the previous step, as these forms too have a spot for only a single guardian and a single child. You should now have a stack of papers that, when placed face up, should be broken into forms in the order that the court expects them. If you are filing a fee waiver with your packet, you should place your request to waive fees and order on fee waiver first in the packet, with each one paperclipped. One at a time, make 2 copies of each paperclip document. If you have access to a copier with a document feeder, the process of copying will be much easier. For each paperclip document that you copy, staple each of the 2 copies and then paperclip them behind the unstapled original. You should end up with a stack of documents following the same order of the copying and filing checklist. After you have completed your copying and placed your forms into order, you are ready to file them at the probate department. The Sacramento County Superior Court's probate department is located on the 2nd floor of the Family Relations Courthouse, located at 3341 Power Inn Road, just south of Folsom Boulevard. At the time you file your documents, unless you file a fee waiver request, the court will collect your first appearance fee, which at the time of this program is $225. Assuming that your documents are in order and there are no obvious mistakes, the clerk will keep your original documents, stamp copies, and return the copies to you, with the exception of the orders appointing guardian and the letters of guardianship, which will be held by the court. You will also be given a hearing date, time, and department, which will be written in the upper right-hand corner of your petition for appointment of guardian of the person. Once your documents have been returned to you, you are ready for your next step, serving notice on relatives. Now that you have filed, your guardianship case has been given a case number as well as a hearing date, time, and department. Your next step is to provide legal notice to the relatives of the child that you have filed for guardianship. Your first step in doing this is to complete the Notice of Hearing, Guardianship, or Conservatorship, which is contained in the Guardianship Part 2 packet, which may be downloaded from the Sacramento County Superior Court or may be individually downloaded through the Judicial Council's website. The form number for this form is GC-020. By now, the top caption of the form should be familiar to you. In the top box where it says Attorney or Party Without Attorney, complete your name, address, and telephone number, and then write in pro per in the line that says Attorney for. If two or more of you are applying for guardianship in your petition, write the first person's name, followed by an ampersand or the word and then the next name. This will allow the clerk to know that the names are separate and not part of a single long name. If you downloaded the Part 2 packet from the court, the next box contains the court information already filled in. If you downloaded the form elsewhere, pause this video and copy the court information onto your form. Below that, check the boxes for guardianship, person, and minor, and then in the box write the name of the child or children you are seeking guardianship of. Then, copy your case number into the box that says Case Number to the right. This is the number stamped on the first page of each of your forms that, in Sacramento, begins with a 34, a dash followed by the year you first filed the case, then a dash followed by 8 digits. In Sacramento, if for any reason any letters follow the end of the numbers, you may ignore these letters. In paragraph 1, after the words "Notice is given that," write the name or names that you wrote in the caption at the top of the page. Skip over the line that says "Representative capacity, if any," and then after "has filed," write "Petition for appointment of guardian of the person," as shown on the screen. This alerts the court and relatives to know that you have filed a form called Petition for Appointment of Guardian of the Person with the probate court. Skip over items 2 and 3. When you reach item 4, check the department box, and then write the date, time, and department number for your hearing. This information is listed on the upper right of the Petition for Appointment of Guardian of Minor form that the clerk returned to you after writing this information. Just below that, in section 4B, check the box that says Same as noted above. You are now ready to have relatives served with notice. Each relative that will require service will receive a copy of this Notice of Hearing, Guardianship, or Conservatorship form, as well as a copy of your guardianship petition, Form GC-210P, including all of the child information attachments, Form GC-210CA, that were included in your filing. You will need to make additional copies of the notice and guardianship petition with attachments so that you have enough copies to have each of the relatives served. The law requires that at least 15 days prior to the guardianship hearing, the following relatives be served with a copy of the Notice of Hearing as well as a copy of the Petition for Appointment of Guardian of the Minor. The minor child you are seeking guardianship of if he or she is 12 years old or older, the parents of that child, any brothers and sisters of that child who are 12 years old or older, including any half-brothers or sisters, and finally, the grandparents of that child. No other relatives need be served with notice. In addition, if there is already a guardianship for the child, his or her current guardian must be served with notice and the copy of the petition. And finally, if the child has Native American ancestry, then additional notices will be required, which will be discussed in another video. While any person can be served by personal service, the parents of the child for which you are seeking guardianship, as well as the child him or herself if he or she is 12 years old or older, are the only persons that must be served by personal service. This means that someone over the age of 18 who isn't a party to this case, meaning not you, or anyone who would be entitled to receive notice of this hearing, should walk up to the person being served, confirm his or her identity, and hand over a copy of the notice of hearing, guardianship, or conservatorship, as well as a copy of the petition. Ideally, the process should go relatively painlessly, like so.
Are you John Smith?
Yes. What do you want?
I have some important legal documents for you.
Thank you. One of the most common questions is what to do if the person won't accept the papers. As long as the server has face-to-face contact with the person to be served, the server may then leave the documents in the presence of the relative to be served, which would look something like this.
I have some important legal documents for you.
I don't want those.
I'll just leave them here with you then.
Once the service is complete, the server completes a proof of personal service form. Although there are several different types, the form GC-020P is shown. This form has the benefit of permitting a server to list multiple persons being served on the same form. If one person serves one or more persons and another serves another person, they would each create their own proof of service form. At the top of this form, you would check the boxes for guardianship, person, and minor, and write the name of the child or children for which you are seeking guardianship. In paragraph 3, check the box to indicate that the server gave the people being served a copy of the notice of hearing as well as a copy of the petition for appointment of guardian. Below that, in item 5, the box for A, not a registered process server, is checked. If you used a professional process server, the server would be familiar with the forms and would provide one for you. In paragraph 6, the name, address, and telephone number of the person who served the papers for you is written. Remember, this cannot be you or someone else who is entitled to have notice of this hearing. In the boxes below, the name of the person served is written in a left-hand side box. The address where service took place is printed in the middle box, and finally, the date and time that person was served is filled in on the right-hand side. This address does not need to be a home address or a work address. It is merely the address where service took place. Once the serves are complete, the server dates and signs on the left bottom of the form. The signature line on the right-hand bottom is not used. Once this is complete, attach this as the third page to the Notice of Hearing, Guardianship, or Conservatorship. The grandparents of the minor and any of his or her siblings 12 years of age or older can be served by mail. Once again, this service must be performed by someone over the age of 18 who is not a party in this case. To serve, the person serving needs to mail a copy of the Notice of Hearing, Guardianship, or Conservatorship, as well as a copy of the petition for appointment of guardian of the person to each of these relatives. The proof of service by first-class mail is already the second page of the Notice of Hearing, Guardianship, or Conservatorship form. This proof of service should be completed but not signed prior to mailing. At the top of the form, check the boxes for guardianship, person, and minor, and write the name of the child or children for which you are seeking guardianship. Write the case number in the upper right-hand corner. In the middle of the page, for item 2, write the address of the person who is serving the documents for you by mail. In paragraph 3, check the box for depositing. Depositing means that the server is placing a copy of the documents with enough postage in a mailbox or mailing them from a post office. In 4A, the date of mailing is written down, and in 4B, the city and state from which mailing is taking place is written. Box 5 should be checked to indicate that the person is mailing both a copy of the notice of hearing with proof of service by mail and a copy of the petition for appointment of guardian of the person with any childhood information attachments. Finally, the date of signing and the name of the server is printed below. At the very bottom of the form, list the name of the person or persons being served in the boxes on the left and their address as it appears on the envelope in the boxes to the right. Make as many copies of the notice of hearing, guardianship or conservatorship, and petition for appointment of guardian of the person as you need to mail each person listed a copy. The server then mails the forms to each of the persons listed. Mailing should be by regular first-class mail. Do not use certified or registered mail, as there is a good chance those will result in your mailing being returned without the recipient receiving notice of the hearing. Once mailing is complete, the server signs his or her name on the signature line. If you have had any persons personally served, attach the proof of personal service to the end of this form, and then make 2 more copies. The copies are each stapled, but as with your prior documents, the original is not stapled. File these with the court, preferably at least 15 days prior to your hearing. In the next segment, we will discuss handling relatives whose identities are not known or who are difficult or impossible to locate for service. Many people going through the guardianship process find that there is at least one relative that is entitled to notice of the proceedings that is either unknown or can't be located. If you already know the identity and location of the minor child's parents, grandparents, and siblings over age 12, you may skip this video. For anyone with at least one or more relatives that are unknown or cannot be located, this video will discuss finding these relatives and asking the court to excuse providing notice to them if they cannot be found or identified. In Sacramento, the court has developed a mandatory local form to be used to document your attempts to identify or locate a relative and ask that the court dispense with notice to that person. One copy of this form, Local Form PRELP-010, needs to be completed for each relative that cannot be located. This form walks you through the minimum efforts that the court wishes to see made in an attempt to locate someone before it will consider dispensing with notice to that person. The top caption of the form is much like the forms that you have already completed, including the top box in which you write your name, address, and telephone number. In pro per can be written in the attorney for area. In the box below the court's address, check the box to indicate that this form is being used in a guardianship and write the name of the child or children. To the right, fill in the case number, and below that the hearing date and time. If you read this form carefully, it will make sense when read with your filled-in information. On the first line, after name of the person I need to give notice to is, write the name of the relative you cannot locate or cannot identify. If you do not know the name of the person, you may use unknown and the description of who the person is, such as unknown paternal grandfather. The next line is the last known address for this person. If you know it, write it in. Otherwise, write as much information as you have, or unknown if you have none. The next line is the approximate date when the person last lived at that address. Obviously, if no last address is known, the answer to this would also be unknown. In the 3 checkboxes, check the first box that begins guardianship only, And then at the end of that line, write the relationship of that person to the child or children in the guardianship proceeding. Examples include mother, father, brother, sister, maternal grandmother, paternal grandfather, etc. Your first step in locating someone is to typically ask relatives of that person where they are. Contact relatives you know of for the person you are seeking and take careful notes.
Hello, are you Mary Simmons? Hi, this is Peggy Lee. I'm Roger's mother, the other grandmother of Haley. That's right, we met once last December. Haley has been living with me for the last couple of months, and I am applying to become her guardian. I am going to have some documents mailed to you about this, but I also need to get a copy of this to your daughter Melissa. You wouldn't happen to know how I could get into contact with her, would you? You neither? Well, thanks anyways. If you find out where she is, would you mind giving me a call to let me know? Yes, that's my number. Thank you so much. Bye.
In paragraph 1, you will write the names in relationship to the person you are seeking of each relative you contact, as well as the address and telephone number of that relative. Below that, in the results of interview and additional information received, summarize what you learned. If you are unable to contact any relatives, indicate none for the name of the relative and indicate why you could not contact them in the space below. For example, if the person you are seeking is an unknown father, you might not know any relatives for him. Whatever the circumstances, briefly describe what you learned or explain why you were unable to contact any relatives. The same process is repeated except for friends in paragraph 2 and employers in paragraph 3. When completing the first 3 paragraphs, it is possible you might know relatives but not friends and employers, or maybe employers but not relatives or friends. Whatever the circumstances, be sure to explain in each paragraph in clear, concise language what you learned. In paragraph 4, for whatever cities you have reason to believe the relative might be living, look through the residential white pages for that city or town and call the information operator asking for that person. Indicate the date, city, and state involved in the search and the results where indicated. Fewer and fewer places these days publish residential white pages. If you are searching one of these areas, you may not be able to locate a copy of the white pages to search, but you will still be able to call information to see if the person has a listed number. Paragraph 5 requires that you search the index of the Recorder and Assessor's Office of any county the person you are searching for may live or have property. In most counties, you can do this first part online. Many of the recorder's offices maintain an online index of documents. This will allow you to determine if any documents have been recorded. Unfortunately, the law prohibits them from placing these documents online, so if you find a potentially relevant document, you will either need to view the document at the recorder's office or order a copy by mail. The Sacramento County Clerk Recorder's website is located at the address listed on the screen. Once you are on this page, click the large link that says Record Search. You will be redirected to a page on a system called eRosie. On the search page, enter the person's last name and at least the first couple of letters of their first name. Next, select a decade to search, starting with the most recent, for example, 2010. Depending on how common the name is, your search will result in a list of documents or indicate that no records match your search. There are a lot of different types of documents that are recorded. However, a number of them can be ignored, while others may have the information that you are looking for. First, ignore any documents indicating that they are listed as deeds of trust. These are financial documents pertaining to mortgages, where the right to foreclose in the event of a default is being assigned to a trustee. Next, ignore utility liens. These documents will typically list dozens to hundreds of names. Instead, focus on grant or quitclaim deeds where the person you are seeking is listed as a grantee. Also, look for judgments where that person is listed as the debtor. Judgments are useful because an abstract of judgment will typically list the last known address of the debtor. Deeds themselves don't have the property address on them. However, the assessor's parcel number or APN listed on the deed can be used to search the county tax assessor's parcel viewer to provide an address. Follow any leads that you may find and write down the results. Moving on to paragraph 6, you will need to search for the person you are trying to find on the internet. The court does not expect you to use pay sites, but expects you to use anything you would reasonably use to find a person for free. This would include websites such as Facebook, Google, Twitter, and other sites that have public profiles for individuals that you can locate. Write down the name of the websites that you used where it says location, and then the date that you did your search. After that, indicate what results you found. When doing this search, try to imagine the steps you would take trying to find a long-lost classmate or friend. For paragraph 7, you will need to see if the person you are seeking is in prison or jail. Jails are operated by the counties under the watch of the county's sheriff's department. Sacramento's 2 jails, downtown, and the Rio Cosumnes Correctional Center, or RCCC, are operated by the Sacramento County Sheriff. To see if the person is in either of these facilities, on the internet, connect to www.sacsheriff.com. On that page, scroll down and you will find a link that says View Inmate Booking and Location Info. Select it. On the next page that pops up, choose the link to search by name. Enter the name of the person you are seeking, and the result will indicate whether a person with that name has been booked into the jail and is currently there. Use the other information indicated in the listing to determine if this is the person that you are seeking. Many states provide a means of looking at whether a person is in state prison. The easiest way to do this in California is to use the CDCR Inmate Locator Service. You may go to this online by going to the URL inmatelocator.cdcr.ca.gov. Once you are at that page, agree to the terms and conditions to begin your search. Enter the last name and the first few letters of the first name of the person you are seeking and press search. Once you do this, you will see a list of inmates, if any, that match that search criteria. Use the age and admission date to narrow your search if more than one inmate matches your criteria. Once you have done that, make a note of the inmate number and click on the facility holding the inmate to obtain that facility's contact information. If you locate an inmate in either prison or jail, they may be easily served by either contacting the sheriff operating the jail and arranging to have that inmate served, or by contacting the prison and finding out what their specific directions are to have an inmate served. If you do not locate the person, make a note of the search that you did, and once you have done this, write the date that you conducted the search in the spot provided, and below the results of what you found out. Finally, if there is any additional information that you believe the court may find useful to determine that the person you are seeking cannot be located, write this information in paragraph 8. This is particularly useful in situations where very little is known about the person, as it can be used to explain the circumstances as to why so little is known, or the circumstances under which contact with this person was originally lost. Finally, to complete this form, where it says, "Despite my diligent efforts, I have not been able to find," write the name of the person you are seeking, and then after, "and therefore ask the court's permission to dispense with notice to," write this person's name again. Finally, date, sign, and print your name where indicated at the bottom. Now that you have done this, make 2 copies of this form. Leave the original form unstapled, but staple each of the 2 copies, and file it with the probate court, in the same place that you filed the guardianship to begin with. The court clerk will keep the original and will stamp the copies and return them to you. There is no charge for filing this document in your case. In some instances, one or more of the relatives entitled to receive notice of the guardianship hearing agrees with you that you should be appointed guardian and is willing to waive their right to be served with a copy of the notice of hearing and petition for appointment of guardian of the person and attachments. In this case, the person agreeing to this may sign a consent to appointment of guardian and waiver of notice form. If the relative signs this form, you may file it with the court instead of a proof of service showing that relative was served. The consent to appointment of guardian and waiver of notice not only saves the effort of having someone over 18 who is not one of the people involved in the case serve a copy of the notice and petition, but also frees you from the need to have that service completed at least 15 days before the hearing. Because the person signing the form states that they agree that they do not need to be timely served, this consent is extremely useful in solving service problems when you have an agreeable relative that for some reason you have not been able to have served at least 15 days prior to the hearing. As long as the waiver is signed and filed with the court prior to the hearing, you have met your obligation to have that relative served, although if it is filed close to the hearing, you will need to mention that you have filed or are filing this waiver when you respond to probate notes. The consent to appointment of guardian and waiver of notice is part of Form GC 211. The top caption of this form is what you would expect. As a self-represented petitioner, your name, address, and telephone number go in the box marked Attorney or Party Without Attorney. Your email address is optional and is generally not used by the Sacramento court. On the line that says Attorney for, write in pro per to indicate that you are representing yourself. The county and address of the court are printed in the box below. The information for the Sacramento County Probate Court is shown. In the box below that, after the words guardianship of the, check the box that says person and then write the name of the minor or minors you are seeking guardianship of in the space immediately below. If there is not enough space, you may write the name of the first minor followed by the words et al. To indicate that there are others. Insert the case number where indicated on the right-hand side of the form. In the final box of the caption are 3 check boxes. This form combines 3 different forms that have been placed onto a single page. Check the 3rd box down in front of Consent to Appointment of Guardian and Waiver of Notice. Below that, skip over numbered paragraphs 1, 2, and 3 as you will not be using them. The first paragraph is used only in situations where the person who is petitioning for appointment of guardian is not the guardian, and the second section is only used in situations where a parent is petitioning for appointment of a guardian. Paragraph 4 is what applies to your situation. In the box after the words, I consent to appointment of the guardian as requested in the petition for appointment of guardian of minor filed on date, write the date that you filed your petition with the court. Below that, each person who consents and wishes to waive notice dates on one line where indicated, prints their name, signs, and in the final line indicates how they are related to the child or children for which you are seeking guardianship. Up to 3 people may sign this form. If there are additional relatives giving consent, you may attach an additional page with dates, names, and signatures and relationship labeled as Attachment 4 at the top, or you may instead use another copy of Form GC 211. Once the form is complete, make 2 additional copies and file the original and the 2 copies with the court at 3341 Power Inn Road, Room 214 in Sacramento, just as you did the other documents in your case. If no relatives are waiving notice, you do not need to complete or file this form. At some point, after you have filed your petition for appointment of guardian of the person, you will have a home visit by the court's probate investigator, or if you are not related to the child, by the court's CPS liaison. Do not be alarmed if you do not hear from this person right away, as it is very common for this visit to be fairly close to your hearing date due to the backlog at the courts. Preparing for your home visit shouldn't be too difficult. First, keep in mind that the investigator is not going to suddenly drop in and try to surprise you. He or she wishes to speak to you and everyone in your household, so will schedule a time to be sure that everyone is there. The probate investigator will be the one person in the case that you have the greatest opportunity to speak to about the details of the case. He or she, by the time the home visit is done, should understand completely what the situation is and why the guardianship is necessary, so please be frank with him or her. The investigator really wants to understand the situation so that he or she can weigh all of the possible options and make a recommendation that is in the child or children's best interests. If it's important, be sure to mention it. The investigator will then prepare a report summarizing what he or she has found and make a recommendation to the court regarding whether the guardianship should be granted and also as to what to do with the investigation fee. In theory, you should receive a copy of this report prior to your hearing, but as a practical matter, due to the delays in the court system, you may receive it at the hearing. In Sacramento, approximately 2 weeks before your guardianship hearing, the court will review your case file to see if there is anything remaining to be done and create some notes regarding your case to assist the court. These notes are referred to as probate notes. In the event that these notes state in your case that there is something remaining for you to do, you will be required to draft a response to these probate notes and file it with the court at least 5 days prior to your hearing. The easiest way to access your probate notes is to view them using the court's website at www.saccourt.ca.gov. Once you're at the main page, click on the link that says View Civil and Probate Case Documents. On the next screen, select the tab for Probate, and when the menu drops down, select View Probate Notes by Case. At the prompt that appears next, input your case number, choosing the 4-digit year in your case number with the drop-down box, and entering the 8-digit number that follows. If your probate notes have been prepared, a result should appear that you can click to view. Upon clicking, your probate notes should appear. If they appear with gray lines diagonally across the page, you may have gone to the wrong menu. Be sure to choose View Probate Notes by Case in the prior step. It is free to view the probate notes, and they should appear without any redaction. The top of the probate note will include information about your case, including the name of the minor, the name and relationship of the petitioner to the minor, as well as additional information to assist the court. The next section will usually state documents to be filed by the court by petitioner, or may contain some other mention that the petitioner is required to complete one or more steps. If this section does not exist or is empty, there would be no need to respond to the probate notes. If the clerk found an issue that is necessary to resolve, a note beginning with the word needed will be made for each issue. For each issue, a written response is required. In Sacramento, probate notes must be responded to using a local form, Form PR-E-LP-022, Response to Calendar Notes. This form is easy to use. In the box that says Party Without Attorney or Attorney, simply write your name, street address, city, state, and SIP, and telephone number, and where it says Attorney for, in pro per. In the next box, check the box for guardianship of, write the name of the minor child or children you are seeking guardianship of, and check the box that says minor. Write your case number in the box for case number, and where it provides the space for the date, write the date of your hearing, the time of your hearing, and the department of your hearing where indicated. Copy the text of your first probate note behind the words "First Calendar Note." Please be aware that you may not have enough space to write the complete note. Then, behind the word "Response," write your response to the probate note, explaining to the court what you have done to correct the issue or how you intend to correct the issue. In the example shown on screen, the first probate note is requiring proof of personal service on each of the parents, or a declaration regarding the effort to identify and locate for service the parent. The response might be an indication that one of the parents was served by personal service and when, as well as the fact that the other parent could not be identified and that a declaration of diligent search and request to dispense with notice is being filed with the court. There are no magic words when responding to the probate notes. Simply try to explain clearly and concisely what you are doing or what you have done to provide the court with what it is requested. If you require additional space, you may indicate that your response is continued on an attachment, and then attach an additional sheet of paper to your response using either 28-line pleading paper or the Attachment to Judicial Council form, labeling it attachment number and then the number of the probate note. At the bottom, date, print your name, and sign where indicated. If you have more than one probate note, you will find that there is space for additional probate notes on the second page, the third page, and the fourth page. There is also a signature line at the bottom of each. Use as many pages as necessary. The pages that are blank do not need to be signed. Once you have completed this form, make 2 additional copies of it, leaving the original, if more than one page, unstapled, but stapling the copies. Then, file this with the court at least 5 days prior to your hearing. Your filing location is the same location you have used for all of your other documents.